So today we are diving deep into what is, well, a massive legislative shakeup hitting residential tenancy laws for 2025 and 2026.
Right.
And this isn't about minor tweaks. We're talking about a global reset button for how renting works.
Exactly. We've compiled sources showing jurisdictions from India to the U.S. to the U.K., all sort of simultaneously recalibrating that landlord-tenant relationship.
And it seems to center on three core issues.
It does. Entry costs, transparency through digitalization, and eviction security.
Okay, let's unpack this, starting with the barrier that, keeps most people out, the cost of entry, specifically the security deposit.
The change in India under the Home Rent Rules 2025 is historic. For residential properties, security deposits are now legally capped.
At what?
A maximum of 2 months' rent.
And historically, we're talking about landlords demanding, 6 to 10 months rent up front. That's a huge barrier.
A massive capital outlay. So capping it at 2 months suddenly boosts labor mobility and frees up significant cash for millions of renters.
It's a huge injection of liquidity.
Absolutely. Now, contrast that with New York, where protections are even tighter.
Tighter how?
Deposits are capped at just 1 month's rent. They have to be returned within 14 days. And application fees, limited to only $20.
Wow. And here's where it gets really interesting with those small fees. California's new rules, starting January 1st, 2025.
I think I know what you're going to say, the check cashing fee.
Exactly. They're banning landlords from charging a fee if a tenant simply chooses to pay by check. It's a small detail, but it speaks volumes, right?
It does. It's part of a global pushback against, well, nickel and diming tenants.
And that move against fees leads us straight into our next area, transparency.
Formalization. India isn't just capping money. They're forcing every residential agreement to be in a government-prescribed digital format, registered online.
So this completely eliminates decades of those vague verbal agreements.
It's meant to.
Yeah.
But forcing a digital agreement across a huge, diverse country like that,
You're going to run into access issues, right? For people without reliable digital infrastructure.
that is a critical infrastructure challenge, yes. But the intent is high transparency.
Okay.
And part of that mandatory digital process also requires photo documentation of the property condition.
At move in and move out.
Correct. And that's explicitly designed to prevent disputes over, false damage claims.
Meanwhile, California is using digitalization for a completely different reason.
For the tenant's financial benefit.
All right. New laws are mandating that landlords must offer tenants the option of reporting their positive rental payments to a credit agency.
Which is a fundamental shift. It normalizes rent as a credit-building activity.
As long as the fee is reasonable.
Right. The fee for the service is capped at $10 per month, or the actual cost, whichever is less.
Okay, shifting now to the third major category, eviction security. The UK's Renters' Rights Act is ending Section 21 evictions. What exactly did Section 21 allow?
Section 21 was the no-fault eviction. I mean, a landlord could reclaim their property without needing to give the tenant any reason whatsoever.
So ending that just fundamentally shifts the power balance.
It does. Landlords now need genuine, clarified legal grounds, like selling the property or moving in themselves, and often must provide 4 months' notice.
That's a drastic increase in tenant stability. On the flip side, what's happening elsewhere?
Well, across the globe, India is tackling its notorious court delays by funneling disputes to dedicated rent tribunals.
And these are mandated to be quick.
Very quick. The goal is to resolve eviction cases within just 60 days from the filing date. That's fast justice.
Wow.
But this also raises a question about personal safety. And California has quietly introduced a crucial safety measure.
What's that?
The law requires certain landlords to change the locks at their own expense if a tenant provides documentation that they or a household member is a victim of abuse or violence.
It's sobering that a law like that is necessary, but it shows how critical housing legislation is for real personal security.
It really does.
So when we connect all these dots, what does it all mean?
The pattern is unmistakable. We're seeing formalized, digitized contracts, rigorous legal standards, and, well, serious consequences for noncompliance.
These aren't suggestions anymore.
No, they are mandates, backed by severe penalties, like the UK establishing civil fines up to £40,000 for serious noncompliance.
So the old informal handshake agreement model of renting is basically dying.
It's being replaced by globally connected, rigorous legislation. Precisely.
And that leaves us with the final question for you to chew on. How will mandatory digital agreements, combined with the positive reporting of rent payments, accelerate this global transformation? turning renting from a localized gentleman's agreement into a standardized, fully credit-linked financial activity.